House Bill 675. I apologize, Madam AG.
No, it's fine. Here at your pleasure.
All right.
Even you are, sir.
What you doing there, not a committee?
I appreciate you having me for a couple bills, sir.
He ain't part of appropriations.
I know. I'm honored to pinch hit for a couple bills.
Okay. All right. We got new staff going to read in the bill.
Thank you, Mr. Chairman. Members, this is House Bill 675 by Representative Glorioso. It provides relative to post-conviction relief.
Representative Glorioso on your bill.
Thank you, Mr. Chairman, members. This is a bill that addresses issues with the post-conviction relief system. It makes some major reforms to how the procedures work in that system. And we do have an updated fiscal note, I believe was passed out to the committee today. We had some amendments that were prepared for committee. Mr. Chairman, I'm going to hold those amendments for the floor so we can make sure they're in 100% the correct procedure. They're all procedural amendments, but I believe the updated fiscal note is based upon the amendments that we put on in the Criminal Justice Committee. So I believe that updated fiscal note that you received today is based upon what we've already done to the bill. I don't think the new amendments will change the fiscal note in any way. It's mostly procedural cleanup that we're doing. So with that, I'll turn it over to the AG.
Okay.
Thank you, Mr. Chairman and members, for hearing this important bill, and I would appreciate your support in being able to get this bill out of appropriations so we can move it forward. State post-conviction relief is a procedure. It is entirely procedural. It is a procedure that the legislature has permitted to allow people who have been convicted of a crime a mechanism to challenge the legality of their detention through another sort of process after they've appealed their conviction. And obviously that appeal would have been unsuccessful or they wouldn't be in PCR. It is not constitutionally mandated, but we provide it. This bill puts some discipline into the system. It provides deadlines. It ensures that it will move more quickly. And I would just like to tell you about a couple of cases. I mean, and these are death penalty cases that are predominantly the ones that have exploited weaknesses in this system and the lack of discipline in this system. Nathaniel Code was convicted and given the death penalty after a crime that was committed in 1987. It's been 40 years since he committed his crimes. It's been 35 years since his conviction, and we still haven't been able to carry out the death penalty in that case. Todd Wessinger and Mr. Gazzardo is here. He's been here. You're all familiar with Mr. Wayne. 30 years since that crime, 28 years since the conviction. Henry Broadway, another Baton Rouge case, 32 years since the crime, 30 years since conviction, and that was the Corporal Betty Smothers case. I could sit here and go through all of the cases, and they all have lengthy delays. The system has been weaponized to create and cause delay in this system. For those people who are not death penalty cases, their cases just don't move as quickly because they flounder in the system too. So it's good for them to move more quickly. The death penalty cases are served by weaponizing a system that isn't constitutionally required, but that has been used to create enormous delays. They do get to go to federal habeas after they complete state post-conviction relief, and so the longer they can delay state relief, the longer they can put off federal. I want to move that system forward. The victims of these crimes deserve that. This is a system that we should be funding, and I'm committed to working with you to finding the funding. I would like to point out that you already fund the public defender system and the death penalty cases. Specifically, I think about $2.5 million a year goes to death penalty capital funding, and if they need additional funding to deal with particular cases, the judicial system will address that. They won't move the case forward if it's not funded, the defense isn't funded, and so you need to fix the system first and put the discipline into the system that belongs there. Texas moves these cases in about 2 years. So we've got some that have been out for 40.
Terrell, was something you'd like to add?
Yes, thank you, Representative McFarland. I'm Philip Terrell. I'm the Rapides Parish District Attorney, and I'm here today in reference to a case, a defendant known in the media as the Cheneyville Slasher, it's a Larry Roy case. And the jury determined 40 years ago that that Mr. Roy was guilty of 2 murders by stabbing to death Miss Sally Richard's husband and her 70-year-old aunt who was sick of cancer, dying of cancer, and then slashing the throats of her 8-year-old son and his little brother, who at the time was 6, and Miss Sally's. And he tied them up with an electrical cord and cut their throats and told them that they would be dead before the police got there. Been delay after delay after delay all this time since the jury had convicted Mr. Roy and gave him the death penalty. This last week, we filed a motion to have Mr. Roy to get a death warrant, and that was withdrawn. The court withdrew that. So we had a very emotional hearing in Rapides Parish last Monday. I think some of you may have seen it in the news. Year before last, when Governor Edwards was on the way out, as y'all remember, he attempted to grant clemency to a bunch of people on death row. I think maybe but 2 of them sought that, and Mr. Roy was one of those. My victims had to endure that. They're here today, and one of them is a big monster of a man. The 8-year-old whose throat was cut is not a little fella now, but he can't talk because his vocal cords were cut.
He's 8.
His mother lives in fear every day that she wants to tell y'all very briefly, and I'm not going to take up any more of your time, but from the standpoint of the victims, we would ask that y'all favorably consider the AG's bill.
All right. Representative Marcel for a question.
Thank you. Let me start out by saying my heart goes out to any and all of the victims. However, I'm no longer on criminal justice, so I thought we were just not going to debate the bill itself, but talk about the fiscal note.
Representative Marcel, thank you. I think it does relate to the fiscal note. The question here is whether to move the bill, even though there's a fiscal note on it. And I'm here to tell you that we need to move this bill, that the funding part of it will take care of itself.
Right.
Because the judiciary will determine whether in each case it has the funding in the defense to move the case forward. You do fund the system, and so there is funding there to move these cases.
I don't want to cut you off, Madam Secretary, but I don't have but a few minutes. So I'm going to stay focused on the fiscal note. Mr. Glorioso, Representative Glorioso, tell me, you said that there was an amendment put on in criminal justice and that changed it. Did that lower the fiscal note?
Did. So I
Is
think
this the
originally
actual? Let me say it this way.
Okay.
Is this the actual fiscal note that I have in my hand? Is it 4.1 million?
It was 8 before.
It was 8, so it's been lowered to 4.1.
That's right. We cut it in half, and I think that number is probably still a little high, and I think it's going to be a short-term number as well. What happens is these matters are delayed because they now they can file for the relief but never move it, and it sits there, and then they wait until the AG's office or someone tries to move the case in another area, and then they spring these back in, and it kind of resets the system over and over and over again. And so I think the reason for the fiscal note is that in the short term, the defense side is going to need some money because we're going to expedite the processing of some of these old claims. And so they're anticipating needing additional staff to process those claims that have been held for so long. But those should work their way through the system, I believe, within a couple of years. And so I don't think it's a long-term expense.
So,
and I also think that, I'm sorry, I know.
I'm out of time. Let me go to my next
absorb
point.
some of those
I got
internally.
one more point. So the $4.1 million, is that already in the budget? Is that somewhere we've already identified it, or are these additional dollars?
I think that is additional dollars.
It's additional, I think, on their fiscal note, but it's, remember, you're already funding the system with
Correct, that's why I'm-
2.5, and each case is going to be determined individually in terms of whether it's moving at all. Some of them are in federal habeas, so it's not clear how much they would actually need this year or, or any additional.
Got it,
this
but
year.
my question is, have this $4.1 million already been identified in our budget that we passed? Is it in there already? Are we?
I don't believe it is.
It's not.
It's not?
But my point is, it doesn't need to be.
Okay, Glorioso, what were you saying?
You're correct. It's not in the budget now. So what we're asking the committee to do is to pass this forward subject to appropriations.
Okay.
And we'll continue to work through the system because we believe we're going to be able to lower that number through some additional discussions because as the AG was saying, there's money already allocated.
Right.
And then the judiciary will not move them forward unless the money is there.
Right.
So we dispute whether that money is essentially needed based on the current funding, but we're continuing to work on that. What we're asking the committee to do is move the bill forward subject to appropriations. But as you said, it is not in the budget we passed last week.
Okay, that's what I wanted to know, and thank you so much. I heard some of the testimony, and I just want to say on a personal note, I was friends with Betty Smothers and Warwick Dunn and the entire family. My kids ran track with them. It was horrific. This has my questions have nothing to do with that. I'm here for a fiscal purpose, and that's all I wanted to discuss today. Thank you.
All right. Thank you. Chairman Romero.
Thank you, Mr. Chairman. Good morning. Ms. Morrell, wouldn't the 4.1 be absorbed into the, if you shorten the amount of time that somebody had to spend in jail, wouldn't that money be absorbed into the process? Isn't that what you're trying to say?
Yeah, so you're going to have a lot of cost savings in the long term by moving these cases forward. If it's a non-death penalty case and they're granted relief, then they're out of the system or they're back in pretrial if the DA charges them again and goes through that process. They're out of the DOC system. If it's a death penalty case, you are reducing the number of people who are on death row by moving those cases forward one way or the other, right? So it is going to have a long-term savings that I think will be enormous because right now we are continuing to pay for these cases over and over and over and over again because we have a system that permits that to happen. And, we have created some efficiencies and some discipline in this system that's going to make sure that they get the right to bring the claim, but they don't get to drag it out for 30 and 40 years.
So this bill would fix that. This bill would
fix that.
shorten that time.
Absolutely
It would
fix
fix
that.
Louisiana like other states that don't have this problem. Correct?
That's our objective.
Mr. Chairman, at the proper
Representative
time.
Romero, what I would also like to say on your point, I think is a very important point is that justice delayed is justice denied, both to people who may be wrongly convicted who deserve an expedited process to get that resolved and to the victims who deserve justice for the crimes that have been committed. And so I think this bill will resolve that more expeditiously, ultimately resolve in cost savings, and I believe the additional costs can be absolved into the existing system. And so we don't think that's going to have a major impact on the budget, and we're continuing to work on that.
Right, and to me, it makes perfectly good common sense on both sides, right? Whether people get out early or whether people don't, it's a good measure to me. Mr. Chairman, at the proper time, I would move favorable.
Thank you. I had a question, but my question may be better suited for Remy Starnes, the public defender. Based upon the fiscal analysis from the last 5 years that staff had put together for me, so what I want to account for, Mr. Starnes, is how much money that the state has annually already spent on this, and where are those dollars gone if these cases aren't moving forward? So, for an example, I'm looking at from fiscal year 20 all the way through today, just in capital post-conviction project of, I'm going to butcher this, Malami Center for Justice. I see no less than $2.5 million annually. For that, $365,000, that is contracted with expert witness funding. I see the Loyola Center for School Justice Capital Appeals Projects, $1.2 million, thereabouts. That's just total post-conviction relief contracts. And There's three more on here. And so for a total, that's $7.5 million a year. What are we getting for that?
Thank you, Mr. Chair.
It's on.
Thank you, Mr. Chairman. I'm Ramey Starnes, the State Public Defender. So we don't represent people through the district defender offices for capital litigation at all. For all of our capital litigation, we contract it out to private law firms to do it. We traditionally have done 3 private law firms for trial level work. That is the cases that come up for that first degree murder where death penalty is still on the table. We represent people for about 90 to 100 arrests for first degree murder a year that could be capital. And those 3 firms do that. In the last couple of years, we've merged one of them, the Baton Rouge Capital Conflict Office, with the 19th Public Defender's Office, and we still have 2 presently that we are externally contracted for. Those are
That's the Capital Defense Project of
trial.
Southeast Louisiana,
Yes, sir.
and then the Louisiana Capital Assistance Center.
Yes, sir. That's
Okay.
about 1.28 million a year. The LCAC is 1.39 million a year to do their cases. After trial level work, the process is a direct appeal, which they're entitled to. Everyone's entitled to. And traditionally, that contract has been over $1 million a year. Over the last several years, because of there are just simply not that many capital convictions, there's a couple maybe a year. I try to reduce that contract under the old board structure. It was a very frustrating process. What we did, though, was we had scopes of work to their contract. I've since started that Loyola Law Clinic where we contract with Loyola to provide these services, and that's direct appeals and state post-conviction work. So that contract's $1,050,000 a year.
Okay, but I guess my question is, if these cases haven't moved forward, what have we been doing with all that money each year?
Oh, well, you're talking about the post-conviction.
Yeah.
So the third group are the capital post-conviction, which is the Mwalimu Center for Justice. It was a $1,265,036 a year. It used to be higher. It's been cut. They're the ones who have the bulk of these cases. We represent 40 people who are presently on death row, 31 of them by MCJ, it used to be the Capital Post-Conviction Project of Louisiana, now called the Mwalimu Center for Justice. They have 31. The Loyola Clinic has 9. What they do every year, they investigate, they visit their clients, they file and have hearings when ordered by the courts. Of the 40 petitions, 31 are counsel petitions. That's after copious investigation. They filed their claims for relief where they're seeking constitutional relief. And the Attorney General was correct in the way she stated that it's not constitutionally required, but the post-conviction process is statutorily required, federal statutes, and it's absolutely a necessary thing to do because you have your federal habeas rights, and without the full vetting of issues in state post-conviction, you're severely compromised in federal court about claims that you can raise, which you do have a right to counsel in the federal habeas proceedings. So it's a necessary bridge to have the collateral attack, the civil proceeding that attacks the constitutionality of being incarcerated where appropriate. And it has been expensive. My remedy would be different than the Attorney General's about how to reduce the number of cases that we represent in post-conviction. But they do submit bills every month, and those bills generally are over 100% of their contract amount. So that they're doing work on the cases, which again, investigation, consulting with experts, and filing post-conviction petitions, asking for hearings, and conducting hearings.
So they're ready to go.
They have done a lot of work on these cases. Now, the fiscal note.
But they've done $20 million and nothing's happened in 10 years.
It's extremely expensive, yes, sir.
And now I'm sitting here trying to figure out how I'm going to pay $4 more million when the state's already spent $20 million that I know of.
Yes, sir.
If Representative McFarland, Mr. Chairman, if I could say, their job is to delay. Their job is to not have relief. I mean, they're getting relief by not having this move forward. And so we are, I'm not faulting those lawyers necessarily for the delays that they're exploiting, because these people are on death row. And so every day that they can keep them there is a day that's a good day for them. And for us, it's not, because they have the penalty. We have had direct review. Those convictions have been affirmed. We have provided them this statutory right, and we should allow that process to work. But we need it to move. It is not fair to anybody in this system that we created a system that is now being exploited to deny finality. Our whole system needs finality. And so I think that, they're going to keep billing us. If I clear the decks on these cases, guess what they don't have? Anything to bill us for anymore. So we are going to save money over time. It is important, most of all, that the victims get justice in these cases and that the defendants get justice if they are entitled to it. And so, that's why I think that it is imperative that we fix the system that already exists.
If I may, Mr. Chairman.
Yeah, please.
Presently, of the 40 cases we represent, in 7 of those cases, evidentiary hearings have been ordered and need to be conducted. And under the time limits of the House Bill 675, that's a whole lot to do in a very short period of time, these 7 evidentiary hearings. Also, the 9 remaining shell petitions have to be fully council petitions before the end of the calendar year. That's also a tremendous amount of work to do. It's actually more than we can do in such a short period of time. And with the additional requirements in the time limits that the bill provides, we would need more staff. And I don't know where it's going to come from. And we don't have that many lawyers certified in Louisiana to do capital post-conviction work. I think we hire all the ones that we have. That said, I'm going to follow the law. But none of this money has been budgeted for. We don't have any of this money in our system. This is additional money, to answer your question from earlier, that we would need. And there's an additional big complication here. Under the law, we have revised statute 15:167E. It describes that 75% of all the monies that we're appropriated has to go directly to the districts. This capital post-conviction process are services we contract for that would count on the maximum 25% side. What that means is if we add $4 million to the 25% side to comport with the 75-25 law, we would need even more money that we could send to the districts. So that's a very complicating factor. I don't mind asking for more money from the Appropriations Committee.
I know.
But that is a complicating factor.
And let me say this: we have, I know for the last 4 years, even under Chairman Zerang, gave additional dollars to the Public Defender's Office in support of your efforts. We also recognize that there's been multiple attempts to find a revenue stream for the Public Defender's Office, but in light of that, I'm just still concerned. It concerns me that we've been spending millions of dollars and no movement. And
Mr. Chairman, if I may, I think one of the things this bill will do, it'll force those contracted attorneys to use this money to address the merits of the case instead of using it to delay justice by filing motions that are purely there to continue to delay the process. And so they're getting paid by contract to do this now, and they can use that same money to actually address the merits in a timely manner and resolve these issues as opposed to using the state money to continue to delay the process. And that's what our hope is.
thank you.
Mr. Chairman, if I may.
One more bite at the apple.
Yes,
then.
sir. I just want to talk about the state post-conviction process.
Yeah.
That it's different than the others.
Right.
Here's why. After the state proceedings, you have federal proceedings where the federal courts have a chance to rule on whether a federal constitutional right's been violated or not. And that's a federal district court, it goes to the Court of Appeal. The United States Supreme Court has an opportunity.
And federal government pays for that, right?
The federal government does pay for that. But for those issues that they get to review, that have to be raised at the state and fully vetted in the state level. So when you see a state post-conviction petition, a fully counseled petition, they're often several hundreds of pages with even more pages of attachments, raising hundreds of issues. It's not uncommon, because if you don't raise them in post-conviction, they're waived in federal review. So someone who, the Supreme Court of the United States or an executive, the governor, who is reviewing, make the decision whether or not the sentence is to be carried out or not, we can't leave any stone unturned, and we have to raise all these issues in post-conviction, in state post-conviction. That's why it takes such an enormous amount of time and effort to do. What you view is, well, these motions haven't been filed. But that's not the whole story on the work done in state post-conviction. So I just want to tell y'all that it's not the same as just a regular case when you're talking about litigating in state post-conviction. It's an extremely involved process.
So let me ask you a question. Those attorneys, are they billing us by the hour, or how do they justify their work? Or what is required?
We contract with them on an annual basis for these amounts. They report monthly to us with scopes of work done, broken down by the person doing it, the title of the person doing it, lead attorney, associate attorney, how many hours they've worked on each case. And we compare that to, I think, a standard hourly rate. They don't get paid extra to do it, because the cap is going to be at the amount $1,050,000 for the Loyola one and $1,265,036 for MCJ. That said, they bill us over 100% of the hours monthly, typically, and what happens is they keep working on the cases, and the contracts keep getting renewed every year.
So you're saying they keep a timesheet?
A form of a timesheet. It's not broken down by 6/10 of an hour with the exact scopes of work, exactly what they've done, but they do have records. They tell me they have detailed timesheets, but for confidentiality purposes, we don't make them report those things to us.
What they're doing though is I'm an attorney, so look, give me $1 million a year and tell me I got to bill it, but I don't have to move the case. I'll bill it every year, and I'll find things to do, but I'm not moving the case. Right? We wanted to say is, all right, you got the $1 million, but move the case. All right? So that's what's happening.
All right. I've used up about 9 minutes, so I think I took Representative Francis Thompson's time and everybody else's. But I'm going to have several cards here, if y'all would allow me to read them in at this time. Present willing to speak in support is a designee of Governor Jeff Landry. Christopher Walters, the Deputy Executive Counsel to Governor Landry. Thank you, Rem.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman and members. Christopher Walters, Deputy Executive Counsel for Governor Landry. We just wanted to complete our support for HB 675, and given the testimony that's come before, we don't want to beat a dead horse here, but much of what Representative Glorioso and Attorney General Murrell have said is accurate, that these cases take way too long, and the only reason for doing so is to delay, because the defense attorneys believe that another year that they can keep that person on death row is another year that they have spared their life. Our position is that if there are issues with that case that need to be addressed, then they need to be addressed quickly. We don't want someone on death row for 20 years only to find out that there was a defect in their conviction, or that they were factually innocent even, and that they have sat on death row for 20 years. Those issues should be addressed, and they should be addressed expeditiously. And conversely, if that conviction and that sentence are final and everything is working and that all of those issues have been raised and addressed expeditiously, the punishment should be carried out, and these victims should not have to be dragged for 20 and 30 and 40 years. And remember, every single time they file something, every single time the district attorney or the prosecutor or the attorney general's office has to notify the victim's family, has to drag them through it, and so they are getting notified multiple times a year for 30 to 40 years, every single time, to say, hey, remember how your loved one was murdered? Well, it's time to bring it back up again and talk about something else and talk about another issue. And just specifically to how these cases are handled. I have handled some of these myself in post-conviction. I will tell you that one of these cases that's on death row that the Attorney General is handling, the post-conviction attorneys had 7 experts, all of whom said the exact same thing as the expert before them. They had 3 at the beginning, then they realized those 3 weren't going to hold up to scrutiny, and so they had to get another 3 experts, and it took 10 years from the time that claim started until they were finally able to put something forward, and it took us over a month of evidentiary hearing days to take all of that testimony, when that could have been done with 1 expert or 2 experts at the maximum, but they allowed them to keep on going. And not to mention, they had an entire pro bono law firm that was backing them up on these cases. So we would like to see more transparency with how these cases are being billed or worked, because a lot of this information, a lot of this investigation and all of that happens even pre-trial. That's required pre-trial before they even take this case to trial. So all of this is already there.
All right.
Thank you.
Thank you. There's no questions. Present would not like to speak, but in support, Lance Maxwell with the Governor of Jeff Landry's designee. Present and would like to speak in support of Frederick Richard or Richard.
Chairman, Representatives, me and my family, we want justice.
Would you please introduce yourself?
Frederick Richard,
Thank you.
one of the victims. Me and my family, we want justice. Sure. It's been 32 years. And here to raise my voice like this. Yeah. I'd have been through like 4 or 5 surgeries. See if this works better. Yes. My family still going through it. It's tough, but still surviving. Just want justice.
Yes.
I'm the mother of Frederick Rishaw, Sally Rishaw. We just want justice for death sentence.
Miss Sally and Frederick, Frederick was 8 years old when he had his throat cut and his brother was 6. Miss Sally's throat was cut too. They lived to testify against Larry Roy, and they had to suffer the indignity a week or 2 ago in court of having their death penalty post-conviction relief lawyer chastise the district attorney for asking that the death penalty warrant be set. I mean, you can understand the level of anger and frustration that these people are going through. What they suffered is inconceivable to most of us. The time that has been permitted to sit in the system in their case, which is in post-conviction relief, Mr. Roy was granted an evidentiary hearing something like 10 years ago, and then the lawyers did nothing. They sat on that relief. They did not pursue it. And now that we are moving these cases forward, that Governor Landry and I are, and the district attorneys are moving these cases forward collectively, everybody's awake again. And so they came in and said, oh, we have an evidentiary hearing that we haven't had yet. Our position is those rights were granted to you. You didn't have to pursue them. And so we are litigating that issue, but they had to come to court and sit and listen to the attorney complain about the death warrant being set because it was aggrieving Mr. Roy's mother. I mean, one of the victims was in the room. He said, what about my mother? She was murdered. And Frederick and Miss Sally and their brother had to sit there and listen to this. It is torture for these people. And so we owe them to move the system. We already created this system. We owe the funding to this system to make it work. I'm committed to making sure that that funding exists. If I have to go do it myself, I will. I am not asking you for more money from my office, and I've offered to every district attorney to take every one of these death cases to make sure that they move forward. And so I'm committed to doing what needs to be done. I just need you to support them and support funding and just moving the system forward. We need to fix a broken system. And I think, it is impossible for any of us, I think, to look at these people and listen to these people and hear them and walk this walk with them and not promise them that we're going to fix it.
Thank you, Ms. Sally and Mr. Frederick Richard. Present, support, would like to speak. Well, Attorney General Liz Morrell. Present and in support would like to speak. Wayne Guzzaro.
I'm not going to get into my case because I've been here 60-something times in the 30 years for appeals. I can tell you where a lot of the money goes. They hire, mine has gone through 3 separate appeals all the way to Washington, D.C., where they voted 8-1 to uphold the death penalty.
Would you state your name?
I'm sorry. My name is Wayne Guzzaro.
Thank you.
They voted 8-1. Supreme Court, Washington, D.C., uphold the death penalty. It came back, and they found, which they always do, they find a left-wing judge that'll order another appeal. They appealed for Sotomayor. She's the only one that voted against it. They didn't consider the rest of the 8. They took her information and appealed to Judge Gravier. He didn't even have the decency to call us, which is up until then, to give our side of the story. He just signed off on it. And it's somewhere in between here and there now, but it's been 30 years. And I thought after the first set of appeals that my wife and I could start remembering our daughter as she was. Every time we come here, every time we go to a hearing, every time we go to the pardon board, we have to remember how she died. And it was horrific. She was on 911 begging for her life. And he told her, excuse my language, shut up, bitch. And he killed her. Killed another man going out. And they want to sit there and tell me what a great guy he is. I'll never know what my daughter would have turned out to be. So as long as they're making their money and they can appeal, and up until now, they appeal. If it's turned down, if it's accepted, we appeal. It's 90 days. And you're talking about 180 days before it gets to a different court. And I can tell you in my case, I can't verify for everybody else, but I'm sitting there at a hearing in a federal court, and they fly witnesses, expert witnesses in from Washington, California, Chicago, to testify, who have met with this guy maybe 1 or 2 hours, and then they verify. That's where our money's going, and as long as we keep giving it to them, they have no reason not to do that. And I'll never forget, at the parole hearing I went with Liz, I had one of the defense attorneys look me straight in the eye and say, I'm never going away, ever. Come out of her mouth. It's been 30 years. Please do justice for my daughter.
Yes, sir.
And these people are here in worse shape than I. I didn't see my daughter murdered. These people here watched it. It's ridiculous to go this far with this, sir. And I'm sorry but just give us our justice. That's all we're asking for.
Okay. Thank you for your time. Present in support but not wishing to speak, Monica Doss with the Rapides Parish DA's office. All right. Present would like to speak in opposition? Matilda Carbia. Also have a Robert Morris, both with the same Center for Justice. If you both would like to come to the table at the same time. In opposition, but willing to speak.
Good morning. Thank you, Mr. Chairman. My name is Matilda Carbia, and I am the director of the Mwalimu Center for Justice, which represents people on Louisiana's death row in their capital post-conviction proceedings. And first, I just want to acknowledge the victims' family and victim survivors who are here today and extend my deepest condolences for their loss. And my comments here today and my job are not meant to take away from the pain that is at the heart of these cases and at the center of these families. So I would like to talk a bit about what has happened in capital post-conviction cases in the last many years, as well as what would have to happen with this bill if this bill were to pass and how that affects costs. So first, to Chairman McFarland's question about what has the money been spent on in these last many years, by way of example, from 1999, which is the year that the legislature first created the offices that now do the capital post-conviction work, to 2019, so a 20-year period, there were 70 final resolutions of cases in capital post-conviction proceedings. That included 4 people who were executed, 9 people who were exonerated, and 57 people who had their death sentence permanently reversed. And at that time, there was anywhere from high 90s to low hundreds as far as people who were on death row. When I started this work in 2009, there were well over 90 people on death row, and today we have roughly 55 people on death row. So that also speaks to the very high reversal rate that we have here in Louisiana. There was another question about billing from capital attorneys, and on average, the lawyers who are doing capital post-conviction work, we make on average $49 an hour. That is considerably less than the state hourly rate that contract lawyers are paid who are doing non-capital work. That's also considerably less than the price range that the AG's office is paying to contract with private attorneys, such as in the Antoinette Frank case, where the lawyers are billing between $175 and $300 an hour. AG Merle also brought up Texas and how quickly the process moves there. And I wanted to point out that in Louisiana, our office, who represents 31 of the 40 people in post-conviction proceedings, we have an annual budget of $1.265 million. And in Texas, the capital post-conviction office there has a budget of $3 million to represent fewer people than our office. So that's over twice as much money to represent fewer people.
Thank you, Mr. Chairman and members. I also just wanted to speak to your question about what this money is paying for.
Just state your name, please.
Oh, sorry. My name is Robert Morris. I'm a
Thank
staff
you.
attorney at the Mwalimu Center for Justice. As Director Carbia just pointed out, over the last 20 years, 66 people on death row who shouldn't have been there, and that's as a result of our investigations. That's where the money has gone, and that's 66 people who shouldn't have been there as determined by judges, sometimes even the DA, as a result of the work that we're doing. The reason for the increase in our budget that's required by this bill is plainly stated in the fiscal note, the one that's in front of you today, as well as the previous versions of it. And that's our office is staffed to handle about 12 cases at a time. There's 30, 40 cases pending that would all be activated at once by this bill. That's the reason for the increase. I also just wanted to share with you the importance of the post-conviction process is when you hear about somebody exonerated from death row or somebody who shouldn't have been on death row, that is the post-conviction process. Their trial's already taken place. Something went wrong, and it's discovered in post-conviction. And that's what our office is designed to look for. It's our belief, and I know that there are a lot of members on this committee who do support the death penalty, but it's our belief that if we're going to have the death penalty in Louisiana, you have to do it right. And our office is there to make sure that the people that it's done right.
Got a question from Representative Bagley.
Thank you, Mr. Chairman. So someone that's, let's say he's not on death row, but he's in jail for 40 years, and we still haven't decided what to do with that. How do you justify that?
So, to your question, sir, the current bill that's in front of y'all for appropriations doesn't deal with pretrial folks. And so this is all people who've already been convicted and sentenced to death and had a direct appeal, which is errors at trial, and now they're in the post-conviction process, which has to do with extra record evidence, which is why it requires a lot of investigation. So I don't know that this bill touches people who are in jail pending trial.
Well, what about those people that are in that second row back there behind you, who one group that watched their child be murdered and a man whose daughter was killed, and we're still talking about doing something with them? And I'm not sure, I don't remember, Secretary Merrill, how many years you said it was ago, but if it was 2 years, that'd be too long. And I'm just not understanding the reason that you're giving for this happening, nor I'm sure the Attorney General and Representative Glorioso to explain exactly how we got in this mess. Representative Glorioso did talk about if he had $1 million and could delay forever, then a year, then that's what he'd do. And I understand that's probably what's going on, but and I applaud the Attorney General for trying to come up with an answer for all this, and I do support that. But for the two of you, I'm not sure how you can testify that you're doing the right thing when, if it was your child that you saw murdered, would you be able to do the same thing?
So, sir, part of the context for why things have taken so long is that Louisiana didn't provide lawyers or funding for capital post-conviction cases until 2001. So some of the cases that are still being litigated were a backlog created by the time where Louisiana didn't fund this work. And there is a mandatory appeals process in death cases. And just as a point of clarification, many of the cases that AG Merle mentioned in her testimony, Mr. Code, Mr. Wessinger, and Mr. Broadway, all of those people are now in federal court, and they're not part of the state process that this bill contemplates.
Well, again, if it was your child, and every year they brought you back to court to go back over all the things that happened, and he or she ended up dead, would you still feel the same way about what you're doing now?
Sir, I can't imagine if I was in the position of any of the victims.
And I can't either, but I'm just asking the question.
And at the same time, we've made an obligation here in the state of Louisiana that we want to uphold the promises made in our Constitution. And part of that is ensuring that people had a fair trial.
Okay. Thank you, Mr. Chairman.
Thank you. So I want to go back to the fiscal note. And would you tell me how to say this Center for Justice?
Yes, sir. It's the Mwalimu Center for Justice.
Mwalimu.
Yes.
All right. So the M's silent. Mwalimu.
Yes.
All right. So in the fiscal note, it talks about the manpower to staff 12 of the 40 post-conviction cases currently that the Office of Public Defender is responsible for in the post-conviction stage. So let's say of about the other 30 cases that you have over the last 10 years, I mean, why have we not exonerated those, or what are we doing? That's what I'm trying to understand, because when I sit here and I look at my graph of how much money we've spent.
Sure. So, as additional context, as well as the number that I provided earlier of the 70 final resolutions between 1999 and 2019, our office on average in the last 15 years, which is going back to 2010, we have filed in that time period over 200 substantive filings in our cases, and those all raise serious issues with a person's conviction and or death sentence, and are filed at all levels of the state courts, district court, and Louisiana Supreme Court. And we've also conducted at least one evidentiary hearing per year in those 15 years, sometimes more, but that's an average. And the evidentiary hearings are like a trial or a mini trial without a jury. So a tremendous amount of work and preparation. And of those over 200 substantive filings that have been made in the last 15 years, over 30 of those were full counseled petitions for over 30 different clients. So, we are moving ahead. The cases are moving, and I understand that folks would like to see it move faster, and we don't have a problem with that. We just need to be funded in order to be able to staff the cases properly.
Okay. All right.
Mr. Chairman, I'd also note the Louisiana State Law Institute worked on this issue about 4 years ago and actually ended up drafting a bill that I believe was proposed by Representative Bacala that would have addressed the same issue. And it created deadlines. It created new deadlines for every stage of the process. There's already many deadlines, but it tightened them up. It did a number of things, and it did it without asking for any additional funding for the State Public Defender's Office. So there is a way to do this process in an orderly way that doesn't require this kind of money. It's just this bill seeks to litigate all those cases at the same time with an office that's only staffed to handle 12.
Okay. All right. Representative DeWitt.
Thank you, Mr. Chair. So you have 12 folks in your office at the Center of Justice?
For our staff?
Yes, sir. Yes, ma'am.
We have 6 attorneys,
Okay.
2 full-time investigators, 1 part-time investigator, 3 paralegals, and 2 admin people.
And the Cheneyville slasher case, who was assigned to that? Or one of y'all assigned that?
The Loyola Clinic is assigned to Mr. Roy's case.
Loyola Clinic. And typically, how long does it take on, once you do post-conviction and y'all start y'all's part in this, how long does that usually take on a death row case?
It depends on the deadlines and the way that the litigation moves, because there's a mandatory briefing process, and then it's up to the discretion of the state district court whether an evidentiary hearing is granted. So in a case where a hearing is not granted, the state post-conviction process could get through the district courts much more quickly and then up on writs to the Louisiana Supreme Court than in cases where an evidentiary hearing has been granted, because that requires a whole other round of preparation and litigation.
And typically, when does that take place?
An evidentiary hearing?
Yes, ma'am.
That would take place after the litigation, the paper litigation that is laid out in the code is done. So a state district court is given a petition by the petitioner, the defendant, which is, as Mr. Starnes would say, had already said, can include like hundreds of pages, many, many claims. And then there's a process of the state filing procedural objections. The defendant responds, the state files an answer, the defendant responds, and it's after all of those paper filings have been done and the court has decided them that there's a decision on whether an evidentiary hearing is going to be granted.
And typically, how long does that take?
I don't have a time frame, but it could take anywhere from 2 to 5 years. Would be a guess, but if the committee would like specific numbers, I can get that to y'all.
Well, in that particular case in my parish, 40 years. Right, 38 years, right at it. Why do you think it's taking that long?
Part of that is what I was saying to Representative Bagley a moment ago, which is that these cases were not funded by the state earlier in Louisiana's time of prosecuting people for the death penalty. So we are catching up on a backlog that was created at a time where lawyers weren't identified and paid to do this work.
So, current caseload today, how many staff you need?
If this bill were to pass,
Yes, ma'am.
we would need to at least triple our staff.
Okay. Thank you, Mr. Chair.
Okay, there's no further questions. Thank you.
Thank you.
All right, last one, present willing to speak in opposition. If I say your name incorrectly, I apologize. Sometimes I can't read the writing, and sometimes I just can't say the name. Chiro Yancey?
Sometimes I can't say names either, so it's Checo Yancey. All right. I'm a former incarcerated person, and my concern is that HB 575 is overhauling the entire post-conviction relief system, and it'll affect every case that's impacted that people are in the system. And first of all, my heart goes out to the people here today that had to go through what they had to go through. And I see that they are appealing with the death row cases. And I understand why they're doing it. Nobody has said this will impact the entire system. Currently, there's 3 years for post-conviction. So if someone is in prison, it takes them sometimes 2 years to get out of the parish prison and can't get their records. And by the time they get to the prison and start trying to work on their case, I was an inmate counselor there. They don't get their records, so now you go cutting it from the 3 years to 1 year. What about those people that can't get their records to even appeal their decision? Can't get their transcripts? What about the people that come from the parish and come into the state system, and when they get there, they take their paperwork and throw everything away? What about those people? My heart goes out to the people that's here today, and I realize that they're, like I said, they're doing the death row cases, but this affects the entire post-conviction system. It's already a 3-year limit. Forget your post-conviction to get it in. Nobody has said when a crime is committed, the police come out, they have investigators, the DA get the case, they got investigators, and the lady came before you and she only has 2.5 investigators. What about the people that they found that was exonerated completely and found out they didn't even commit the crime, but it took them 30 years to get their records to get it straight? I'm asking you to consider. Think about the other folks. Yeah, they're talking about death row. I understand that. That's why they're appealing to this committee to get the death row, to get the sympathy. What about the rest of the people that's in the system? That's what I'm here to talk about. Post-conviction right now is a 3-year limit. So now you're going to cut it to a 1-year limit? That's just not fair. And I ask you to consider this is a horrible bill for the people who really doesn't care about fairness. And I understand what they're doing. So thank you for listening to me. Thank you.
Sir.
Kill this bill.
Representative Bagley.
Thank you, Mr. Chairman. Explain to me why it's unfair if someone commits a crime if you got 3 years now, why it's unfair to move back to 1 if we have all the evidence? How is that unfair? Unfair to whom?
Well, it's unfair to the person that's been accused of the crime. Suppose that person really didn't do the crime, Representative Bagley. I mean, and they can't get their records. Now you realize now, do you know the current, what it is now for post-conviction is 3 years. So that means you have 3 years to get all your paperwork so somebody can help you with your case. Most people that's accused of a crime or committed a crime, however you want to say it, maybe they can't read and write, and they got to get someone to help them. They have to get someone to help them. So you're going to cut it to 1 year, and suppose they stay in the parish prison for 2 years and don't get their records. So now they've lost an opportunity to get an appeal. That's the unfairness, sir. That's what I'm saying. Currently, right now, the way I read the law, 930 is 3 years to do your post-conviction. And look like now they're trying to cut it to 1 year. That's why I'm opposed to this bill, sir. Do you understand me?
Oh, I understand what you're saying, but if they are going to drop it to 1 year, I would support that because of all the money it would save. I mean, again, I wouldn't. I'm not sure you'd still have an appeal process, wouldn't you?
Well, the thing about it is, how can you put money before justice?
I'm not putting money before justice.
If it was your child, and that child had 1 year now, had not got his record, his attorney can't get his records and everything, and he's dead, he's killed now and can't file that appeal. That's what I'm saying. That's the only thing I'm saying. I'm saying people need an opportunity to at least file on their case.
Well, I'm saying that seems to me, and I'm not a deputy or lawyer or any of those things. I'm just a person. That
just
a year sounds, and I know people, I know in Steve Prater, when he was sheriff, they talked about they had him in there for 3 or 4 years that had not even come up to court yet. And I know that does go on, but if we had a law where we moved it to 1, possibly could speed up all that. I don't know the answer to that.
Well,
but I'm in favor of doing
And guess
that.
what, Representative Bagley? If you had it 1 year now, someone explain to me how the court person that's going to record the record, get everything prepared, and get it to the person that's accused of the crime, whether they be in the parish jail, that they got an opportunity to appeal and they know nothing about the law. They know nothing about the law.
Thank you, Mr. Acting Speaker. All right, Chair.
Thank you, Representative Bagley. There are no additional questions.
Thank you
for your testimony.
I still don't understand that.
Okay, I'll read a couple more cards that came in. 2 more cards in opposition, not wishing to speak. Evelyn Lescano
We need to fix that.
with myself and representing herself, and Christina Casas. 2 other cards in favor, not wishing to speak. Walter Beach and Mary Susie Labry. Okay. Chairman's back in the seat.
It's all a sham. It's all a big money making.
Would you like to close on your bill?
Yes, thank you, Mr. Chairman. I just want to point out for the committee real quick, the reason we've today addressed the death penalty only is that the fiscal note is 100% related to death penalty cases. The cases that are not death penalty cases, in those cases, we do not fund the post-conviction defense side because we're not constitutionally required to. So that's the reason we've stuck to the fiscal note on the issue. I think you've heard the testimony. You understand where the issues are in this system, that the system itself is broken, and that fixing this system is going to result not only in more expeditious justice, both for the victims and those people who may not have been convicted properly, but also for us as a state to provide less money in the long term to make these cases move faster and more judiciously. So I appreciate you considering moving this bill forward.
Okay. Any other comments?
No, I think we've covered it all.
Okay. All right. Chairman Romero has made a motion to pass House Bill 675 favorable. Seeing no objection, House Bill 675 is reported favorable.
Thank you, members.
Very much.
Thank you.